Okay, and Deputy Cox, just let me know whatever you need from like a housekeeping thing if you have to move from side to side.
Yes,
Um,
sir. Yes, sir.
okay.
Deputy brother, he's in training. I believe he's gonna do good this morning.
Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County.
Buenos días a todos. Esta es su comparecencia inicial en la sala menor de tribunales de primera instancia del condado de Clayton.
My name is Brad Gardner, and I'm a judge in this court.
Yo soy el licenciado Brad Gardner, soy un juez en este tribunal.
I'm not here to conduct a trial of your case or to take a plea in your case.
No estoy aquí para llevar a cabo un juicio en su caso, tampoco para aceptar ninguna declaración a acusaciones.
I am here to inform you of the charges that have been filed against you,
Estoy aquí para informarles de las acusaciones formuladas en su contra,
to advise you of certain rights,
para informarle de ciertos derechos,
to set bail on those offenses that I'm authorized to set bail,
para imponerles fianza para los delitos los cuales tengo la autorización de imponer fianza,
to schedule a preliminary hearing,
para programar su audiencia preliminar
and to determine whether you require the assistance of an attorney.
y también para determinar si requieren el asesoramiento de un abogado.
You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you.
Tienen el derecho de permanecer callados sin decir nada, pero si eligen renunciar a ese derecho, cualquier cosa que digan se puede usar en su contra.
So please don't discuss the facts of your case.
Así que por favor no hablen de los hechos del caso.
During this and all other proceedings, you have the following rights.
Durante esta diligencia y cualquiera que suceda en el futuro, tendrán ustedes los siguientes derechos.
The right to the presumption of innocence,
El derecho a ser presuntos inocentes,
the right to indictment by a grand jury for most felonies or by accusation for misdemeanors,
el derecho a que el jurado de indagación le emiten una acusación formal cuando se trate de delitos graves o que la fiscalía proceda en su contra con una acusación general cuando se trate de delitos menores.
the right to a speedy and public trial by jury,
El derecho a un juicio público y sin demora ante un jurado.
the right to see, hear, and question witnesses who are called to testify against you,
El derecho a ver, a escuchar y a contrainterrogar los testigos convocados a declarar en su contra.
the right to compel the attendance of witnesses to testify on your behalf,
El derecho de obligar que comparezcan testigos para que declaren en su favor.
the right to testify on your own behalf or offer evidence in your own defense,
El derecho a presentar su propio testimonio o también presentar pruebas en su propia defensa.
the right to have an attorney represent you.
El derecho a un abogado que lo represente.
If you cannot afford an attorney, one can be appointed to represent you if you qualify.
Si no puede costear el servicio de un abogado, se le puede designar uno de oficio si cumple los requisitos.
Some of you will be allowed to post unrestricted bonds for your release from jail.
Algunos de ustedes podrán salir bajo fianza, con una fianza no restringida para salir de la cárcel.
These bonds may be posted by cash, commercial, or property.
Se puede depositar fianza con efectivo, poniendo de garantía un inmueble o propiedad o con una compañía comercial de fianzas.
If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office.
Si va a tramitar su fianza en efectivo, alguien tendrá que entregar el total de la fianza más las tarifas correspondientes a la comisaría del sheriff.
The sheriff's office will hold the cash and return it at the end of the case.
La comisaría del sheriff guardará los fondos y se los devolverá una vez que se concluya el caso.
If you use a commercial bonding company, someone will have to pay a fee to the company for their service.
Si va a utilizar una compañía comercial de fianzas, entonces alguien tendrá que pagarle una tarifa a la compañía para ese servicio.
The fee will not be returned.
La tarifa no se le devuelve.
I don't know what fee will be charged, but it is usually based upon a percentage of the bond.
No sé exactamente cuánto es la tarifa que le van a cobrar, pero normalmente se basa en un porcentaje de la fianza.
Finally, if you use property to post the bond, the property will need to have a net equity at least 3 times the total bond amount.
Por último, si quiere tramitar su fianza con un inmueble o propiedad, esa propiedad tendrá que contar con un patrimonio neto de por lo menos 3 veces el valor de la fianza.
Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places.
Algunos de ustedes tendrán una fianza que conlleva condiciones especiales, las cuales impide o prohíbe que tenga contacto con ciertas personas o que vuelvan a ciertos lugares.
This special condition will be provided to you on a separate form.
A usted se le entregará un formulario separado que enumera esas condiciones.
You will also be prohibited from contacting the victim while you are in jail.
También se le prohibirá tener contacto con la víctima mientras está detenido en la cárcel.
If you violate the court's order, your bond will be revoked and you can remain in jail until your trial.
Si incumplen esta orden judicial, su fianza quedará revocado y permanecerán detenidos hasta el juicio.
You could also receive additional felony charges.
También se le podría formular acusaciones mayores adicionales en su contra.
It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond.
También es importante saber que si alguien figura como la presunta víctima del caso, a esa persona no se le permite pagar la fianza por usted.
Some of you are charged with offenses for which this court is not authorized by law to set bail.
Algunos de ustedes se le acusan de delitos los cuales no tengo la autorización de imponerles fianza.
In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date.
Si este es el caso suyo, entonces se programará una audiencia para determinar la fianza ante un juez de la Sala Superior del Condado de Clayton y a usted se le informará de la fecha de la audiencia.
If you are currently on active probation, this court is not authorized to set bond at this time.
Si actualmente está cumpliendo una condena de libertad condicional, no tengo la autorización de imponerle fianza en este momento.
Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest.
Que si es apropiado imponerle una fianza en este caso, esa decisión se tomará durante una reconsideración de la fianza una vez que su agente de libertad condicional haya tenido la oportunidad de considerar este nuevo arresto.
The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you.
El propósito de la audiencia preliminar es para determinar si existen suficientes pruebas para respaldar las alegaciones en su contra.
The standard at this stage is very low.
El estándar de lo que hay que presentar es muy bajo en esta etapa de jurídico.
A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred.
Para que un juez determine en esa etapa judicial que una acusación siga adelante, solamente tiene que determinar si es posible que el delito ocurrió.
Everyone has the ability to waive their right to a preliminary hearing.
Todos pueden renunciar a su derecho a la audiencia preliminar.
However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing.
Sin embargo, debería consultar primero con un abogado si no está seguro si le conviene renunciar o no la audiencia preliminar.
If you post bond, your preliminary hearing is automatically waived.
Si depositan fianza, la audiencia preliminar quedará renunciada automáticamente.
You will receive notice at the address you give of your next court date.
Y recibirá notificación de la próxima audiencia judicial en la dirección que deja registrada en la cárcel.
Finally, I need everyone to raise your right hand.
Por último, si todos pueden levantar la mano derecha, por favor.
Do you swear or affirm that any statements you make during this proceeding will be the truth, the whole truth, so help you God?
juran o afirman que cualquier cosa que digan durante esta audiencia será la verdad y toda la verdad ante Dios lo juran.
Yes, sir.
Okay, let's start with Mr. Cuevas and then Mr. Lopez Wilson, and then we'll go to Mr. Alvear.
Bueno, comencemos primero con el señor Cuevas y luego el señor López Wilson y después el señor Alvear.
Are you Mr. Cuevas, sir?
¿Es usted el señor Cuevas? Your Honor, the interpreter is not hearing a response. I think the jail microphone is on
Oh,
mute.
it is muted. It's muted on the mails. Thank you. Are you Mr. Cuevas?
Hola, señor. ¿Es usted el señor Cuevas? Yes.
Mr. Cuevas, can you see and understand the interpreter?
Señor Cuevas, ¿puede usted ver y entender al intérprete? Yes.
Mr. Cuevas, you've been charged with 1 count of driving a vehicle without a license. The bond is going to be set at $1,000.
Señor Cuevas, a usted se le acusa de una infracción de manejar un vehículo sin licencia. La fianza se impone a $1,000.
Do you believe you can
Okay.
post that bond, sir?
¿Piensa que va a poder depositar la fianza y salir, señor?
Necesitaría hablar.
I would need to make a call.
Okay, you will be allowed to use the phone after this proceeding.
Muy bien, señor. Después de esta audiencia, a usted se le permitirá usar el teléfono.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning, but that date will get waived upon your bonding out.
Señor, su audiencia preliminar se señala para la fecha 15 de junio a las 8:30 de la mañana, pero esa audiencia se renunciará una vez que usted salga bajo fianza.
And you will receive a new court date in the mail.
Y le mandará a notificar de la nueva audiencia por correo. Okay.
Would you like for me to see if you qualify for the appointment of a lawyer?
Quisiera, señor, que yo determine si usted cumple requisitos para un abogado de oficio. No.
Are you going to hire your own lawyer?
¿Va a contratar a su propio abogado, señor? I didn't understand your question.
I'm just asking, are you going to represent yourself on these charges, or are you going to hire your own lawyer?
Solamente estoy preguntando que si usted va a seguir en representación propia o si usted piensa contratar un abogado para representarlo. I'm going to represent myself.
Okay. Do you have any questions of me, Mr. Cuevas?
Está bien, señor. ¿Alguna pregunta, señor Cuevas? No, that was all.
Thank you, sir. You may go back.
Gracias, señor. Ya se puede retirar.
Mr. Lopez Wilson, can you hear and understand the interpreter?
Señor López Wilson, ¿puede usted oír y entender al intérprete? Yes, sir.
Mr. Lopez, you've been charged with 1 count of driving under the influence and 1 count of having an open container in your vehicle.
Bueno, señor, a usted se le acusa de una infracción de manejar bajo los efectos de alcohol y otra infracción de tener un envase de una bebida alcohólica destapada dentro del vehículo.
You're going to have a total bond set at $5,500. Do you believe you can post that bond?
Su fianza total se impone a $5,500. ¿Piensa que va a poder depositar la fianza para salir, señor? Yes, sir.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning.
Su audiencia preliminar se señala para el 15 de junio a las 8:30 de la mañana.
That date will get waived upon your bonding out, and you'll receive a new court date in the mail.
Se renunciará a esta audiencia una vez que salga en libertad bajo fianza y le notificará de la próxima audiencia por correo, señor.
Would you like for me to see if you qualify for the appointment of a lawyer?
Quisiera que yo determine si usted cumple los requisitos para un abogado de oficio.
Yo contrato a mi abogado.
I will hire my attorney.
Okay, do you have any questions of me, sir?
Bueno, señor, ¿alguna pregunta para mí?
Sí, no, voy a hacer una llamada para que paguen la fianza.
May I make a phone call so that they can pay my bond?
Yes, you will be allowed to use the phones after this proceeding.
Sí, señor. Una vez concluida esta audiencia, a usted le van a permitir usar el teléfono.
Otra pregunta, ¿ya lo pueden venir a pagar?
And another question, can they come now and pay?
Yes, sir.
Sí, señor.
Sería todo.
Okay, that's all.
All right. I think that's all. Excuse me, Ms. Tolles.
Bueno.
Mr. Florio is represented that his client speaks English.
All right.
So we won't need your services for him. Thank you.
All right. Have a good day, everyone.
You too. Mr. Alvier, I would normally address you directly, but since you've hired a lawyer, I'm going to speak to Mr. Florio about your charges and about this matter. You should be aware that nothing you say here is considered private. So don't say anything that you don't want the whole world to know, okay?
Yes, sir.
Okay, Mr. Florio.
Yes, sir, Your Honor.
All right, so I see that there was a modification on June 2nd of 2020. You're gonna have to help me out. It looks like there was a why was there 70 days? Why was he required to serve 70
Yes, sir.
days?
Judge, so essentially what happened is Mr. Alvier was arrested on June 22nd of 2016. He was in custody and appeared before the court on September 25th of 2017 and tendered a plea to 4 years probation. The probation department did not give him credit for that, for that 15 months that he had served in custody prior to tendering his plea. And so a probation warrant was issued, or a warrant was issued for Mr. Alvier's arrest for violation of probation. We appeared before the Honorable Judge Mack on June 2nd of 2020. Judge Mack revoked 70 days. That reflected the amount of time that Mr. Alvier had spent in custody prior to that June 2nd of 2020 hearing. And so I think the last sentence of the order should have read time served, case closed. Because having been arrested June 22nd of 2016, his case would have terminated June 22nd of 2020. And we only had 20 days left on probation. So Judge Mack called it even with the 70 days that Mr. Alvier had been in custody.
Okay. So I'm clear on that now. I'm still concerned about just how close this stuff is going on. So I'll hear from you as it relates to bond.
Judge, so I'm not intimately familiar with the facts of the case because it just happened. I've spoken with Mr. Alvier's co-defendant. I believe that there was an automobile stop conducted on Tierra Boulevard in front of the Quick Trip for an alleged window tint violation. It's my understanding that at that time, law enforcement detected the odor of unburnt raw marijuana inside the automobile. Mr. Alvier would have been, I believe, the front seat passenger.
Right.
At that time, I understand the driver made law enforcement aware of approximately 3 to 3.5 grams of marijuana having been located in the automobile, made law enforcement aware of it. That gentleman's name is Freddie Hernandez. Mr. Hernandez has already bonded out this morning.
Right.
What I understand is that at that time, Mr. Hernandez made law enforcement aware of the fact that there was marijuana and that the marijuana was his. I believe a search was conducted of the automobile. No additional drugs were located. I understand, as I understand, there were 3 searches done of Mr. Alvier's person. At that time, no narcotics identified. And both gentlemen were originally arrested for the 3 to 3.5 grams of marijuana located in the automobile. As I understand, when Mr. Alvear was transported and brought into the Clayton County Detention Center, at that time, an additional search was done of Mr. Alvear's person. And I believe at that time, there would have been additional narcotics that were located, those forming the basis of the majority of Mr. Alvear's charges before the court today. That's what I understand. Now, I in full candor, I've not spoken with Mr. Alvear. I've only spoken with his co-defendant. I think one of the things that we would certainly allege, and I know it may be more appropriate for a motion to suppress hearing, as opposed to first appearance in bond, is the legality of the arrest of Mr. Alvear. Certainly, if he's a passenger in a car and he's not the owner of the car, and he was neither the owner nor the driver of the car, there's a legal presumption that both the owner and the driver would have possessed what was located in it. Obviously, that's not Mr. Alvear. Additionally, if you have a co-defendant who's acknowledged there is marijuana in the car, the marijuana, here it is, and it's mine, I think it certainly, certainly there's questions as to why Mr. Alvear was arrested in the first place based off of those facts and the legality of Mr. Alvear's arrest. Certainly, if we were able to establish that Mr. Alvear was illegally arrested, the other charges and what was found subsequent to that illegal arrest, we would obviously argue in Superior Court before Judge Mack that the fruits of that illegal arrest should be suppressed or thrown out. I understand the narcotics were found on his person. I understand that that's an issue. I get that. Certainly alleging it's not ours is difficult. Having said that, though, I do think that there are concerns with his arrest and any subsequent search that would have occurred after that. And so that's one of the reasons I would ask the court to consider setting bond this morning is, I hate to see a young man sit in jail for an extended period of time, ultimately for, a case to be suppressed or thrown out. And I've had that happen before, and I've had that happen recently, where a young man sat in jail 8 months, and then the district attorney's office, and I appreciate them doing it, but ultimately found that there was an illegal search conducted and administratively dismissed the case only after my client had been in custody for 8 months awaiting that administrative dismissal. And it was a drug trafficking case as well. Mr. Alvear is 23 years old. He lives here in the metro Atlanta area here on the south side. His brother has already been to my office this morning to see me. Having represented Mr. Alvear previously, I've had an opportunity to meet with Mr. Alvear's brother and sister and family members. And so I know he has family members. He has ties here in the Southern Crescent. He's retained counsel to represent him. Oftentimes, those that retain counsel, that kind of signals an intent to handle the case and take the case seriously. And so I think certainly I don't know. I don't believe that Mr. Alvear is going to flee the jurisdiction of the court. I don't believe that he would leave the Southern Crescent. He has family support here. And so we would ask that the court set bond this morning. We understand the allegations. We understand the serious nature of the allegations. But we would ask that the court consider setting bond in this matter. To that extent, I don't believe that there's a firearm charge.
No.
And so, obviously, drugs are an issue, but drugs and guns oftentimes are even bigger issues. And so we would also point to the fact that there was no firearm located in the vehicle or on Mr. Alvear's person. It's an allegation of possession of drugs, but no firearm in relation to that.
There's I don't necessarily have a concern about the firearm issue. I've heard that argued successfully in federal court that if you're selling drugs, you basically need a gun because somebody's going to try to rob you at some point in time. So that's my concern right now would be the issue of setting bond. What would be a reasonable bond given Mr. Alvear sort of what I would say is history. And there is a it was 64 grams of alleged crack cocaine that was found in his underwear during the search after his arrest. So I am struggling with what would I consider to be a reasonable bond for someone in Mr. Alvear's position.
Your Honor, we would suggest a bond. I understand. I believe there's 6 charges. One was the misdemeanor marijuana charge. And may I inquire of the court, the other charges, are they also related to that cocaine, or are the additional charges in relation to other drugs having been found?
So essentially, there are 4 charges that appear to apply directly to Mr. Alvear, giving your representation and what I read in the equal access and whether the other person claimed it, is crossing the guard line, trafficking crack cocaine, intent to distribute crack cocaine, and VGCSA possession of crack cocaine.
Okay.
Now, whether I agree or disagree with kind of charging in the alternative, I have to set bonds on those offenses because each one theoretically does exist. And what gets dismissed or dropped or whatever is later not my concern. The possession of less than an ounce of marijuana and possession of 4 oxycodone pills forms the other 2 charges.
Okay.
And so
the only thing I would say in relation to the crossing the guard line, and I've struggled with this over the years, is oftentimes I feel like, a gentleman is placed in a difficult position because you either waive your right to not incriminate yourself and confess that you have narcotics located on your person, or you used your right to not incriminate yourself, and then you get charged with crossing the guard line because the officer wasn't able to locate the narcotics, during a pat down. Kind of, it places a defendant in a difficult position. I would ask that bond be set anywhere in the range from $50,000 to $75,000. I know I understand that there are multiple charges related to the cocaine. And so I understand that bond must be set independently on all that. And so I guess the court could look at it and say, there are 5 felony drug charges. And so we need to address each of those individually. And I guess if that's the position Your Honor were to take, we would ask that bond be set at $75,000. If the court were to look at it as, well, there are four charges, but they appear to be more in line with a single narcotic just charged alternatively, then we would ask that bond be set in the $50,000 range.
Well, I mean, I do take that position, but I also have concern that as a judge, when I'm sitting here and deciding bond, I have to think about the safety of the community. And I have to look at basically the person's conduct. My mentor used to tell clients all the time about, if you cheat on your girlfriend and she takes you back, she's still not going to forget the fact that you cheated on her. And so when you have these situations and, charges may get dismissed or dropped, but when you got similar charges, it starts to kind of look like a pattern. All right, let's see. What I'll do, Mr. Flores, is I'll set a bond at $15,000 each on well, hold on. It'll be 15,000 each on the crossing, guard line, trafficking, cocaine, the possession with intent to distribute and possession, and the appeals. I'll set a bond at $3,000 on the appeals. So that's what, 30, 60, $64,500.
Yes, sir, Your Honor. Thank you, Judge. Thank you.
You're welcome. Anything else, Mr. Florio?
No, sir. No, sir. Thank you, Your Honor, for setting bond this morning. And Mr. Alvear, I'll be in contact with your family members to let them know so we can start the bonding process, sir.
Thank you.
Yes, sir. Thank you.
All right. Thank you, Ms. Florio. You're free to go.
Thank you
Mr.
very much, Judge.
Alvear, you're welcome. Have a good day. Mr. Alvear,
Thank
you're
you.
free to go back.
That's it, sir. Thank you.
Thank you, Your Honor. Have a good day, sir.
You too.
Okay, Your Honor, you can start on the female side.
Okay, let's start with Miss Armstrong.
Sorry for coming up. Step back, sir.
Miss Armstrong, it seems like I saw you 8 days ago.
I think so.
And at that bond hearing, you were told not to go back to 12214 Crestwood Court.
Mhm.
And my understanding is that you went back. That creates the charge of aggravated stalking, and I'm unable to set bond on that charge.
I didn't go
So
back.
you're not going to have a bond on the aggravated stalking. You're going to have a $2,000 bond set on the criminal trespass. I'm also, again, placing a stay away provision for you to stay away from 12214 Crestwood Court. I'm also adding for you to stay away from Jesse Martin. You're going to have a preliminary hearing date set for June 16th at 8:30 in the morning. You're going to also have a bond hearing date set for June 18th at 8:30 in the morning. I've already appointed a lawyer to represent you from last week. So I'm just going to make a notation that you're on bond on that case. And that misdemeanor case now will probably get merged with this felony case and go to whatever courtroom that is going to go to. Do you have any questions of me, ma'am?
No.
Okay, you're free to go back.
Ms. Coward. You can go all the way back up.
Ms. Coward, you're charged with one count of public drunkenness. The bond is automatically set at $1,000. Do you believe you can post that bond?
Yes.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning, but that date is going to get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please. Yes, Your Honor.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, you're free to go back.
Go all the way back. Ms. Daly.
Ms. Daly, you're charged with one count of driving on a suspended license, one count of speeding, and one count of speeding in a highway work zone. I've set a total bond at $2,500. Do you believe you can post that bond, ma'am?
Yes, Your Honor.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning. That date will get waived upon your bonding out and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Is it possible I could unwaive my pulmonary hearing?
You can get out later.
I can figure that out later. Okay, well, never mind. No.
Okay. Okay, you're free to go back, ma'am.
Thank you.
Ms. Hancock. You wait right there.
Ms. Hancock, you're charged with one count of family violence battery, one count of family violence battery as a second offense, which makes it a felony, one count of criminal trespass, one count of aggravated assault by strangulation, 1 count of theft by taking, 1 count of interference with government property, and 1 count of simple assault. I have denied bond on the family violence second charge, and denied bond on the aggravated assault by strangulation, and denied bond on the interference with government property. I've set bonds on the family violence battery at $5,000, criminal trespass at $3,000, theft by taking at $2,000, and simple assault at $3,000. There's going to be a stay away provision on your bond to stay away from James Johnson. Do you understand that?
Yes, sir.
You're going to have a preliminary hearing date set for June 16th at 8:30 in the morning. I'm also going to set a preliminary hearing date for you. I'm sorry, a bond hearing date for you on June 18th at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, ma'am, you're free to go back.
Ms. Hill?
Ms. Hill, you're charged with 1 count of disorderly conduct. The bond is automatically set at $1,500. Do you believe you can post that bond?
Yes.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Moore?
Ms. Moore, you're charged with 1 count of armed robbery and 1 count of criminal trespass, damage to property. I am unable to set bond at this time on the armed robbery charge. I've set a $2,000 bond on the criminal trespass, damage to property. There is also going to be a stay away provision on this bond to stay away from Stephanie Pugh. Do you understand that?
Yes.
You're going to have a preliminary hearing date set for June 16th at 8:30 in the morning. You're going to have a bond hearing date set for June 18th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. I just don't understand the armed robbery part.
The allegation is that you took $3 from Ms. Pugh by brandishing a serrated blade knife.
No,
That's the allegation. And because of that armed robbery, I cannot by law set a bond on that at this hearing.
okay.
All right, you're free to go back, man.
I don't understand the part.
Ms. Thompson?
Ms. Thompson, you're charged with 1 count of battery. The bond is going to be set at $5,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on the bond to stay away from Anaya McCoy. Do you understand that?
Yes.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay, you're going to hire your own lawyer?
Mhm.
Are you going to represent yourself?
Yes.
Okay. Do you have any questions of me, ma'am?
No.
Did you say yes?
No, Your Honor.
Okay, you're free to go back.
And lastly, Ms. Wilson?
How you doing, Your Honor?
Good morning, Ms. Wilson. You're charged with 1 count of aggravated assault with a deadly weapon and 1 count of obstruction of an officer. Bond is not going to be set at this time on the aggravated assault with a deadly weapon. There's a $2,000 bond set on the obstruction charge. You're going to have a preliminary hearing set for June 16th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court. Well, you're not bonding out. You're going to have a bond hearing date set for June 18th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. I don't understand the aggravated battery with a deadly weapon. I didn't threaten anyone. I cut myself.
It's aggravated assault. And the allegation is that you threatened Officer Christopher Davidson with a knife. And that you stated, I'm not going back to prison. You will have to kill me. That's the allegation. So we're not here to determine whether you're guilty or innocent, but now you understand the allegation. You can tell your lawyer this, your lawyer will get these documents and you will know exactly what you need to do to defend yourself.
Yes, sir.
Okay? You're free to go back, ma'am.
Thank you.
You're welcome.
That's it for what I mean, Your Honor.
Okay, thank you. Have a good day.
Your Honor, the first male is Mr. Bates.
Okay.
Good morning, Your Honor.
Good morning, Mr. Bates. You're charged with 1 count of violation of Georgia Controlled Substance Act, 1 count of use or possession of drug-related objects, and 1 count of possession of a weapon during the commission of a crime. You're going to have a total bond set at $15,000. Do you believe you can post that bond? I'm sorry, sir?
Yes, sir.
Okay, your preliminary hearing date is going to be set for June 16th at 8:30 in the morning. That day will get waived upon your bonding out and you'll get a new court date. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. I can find my own lawyer.
Okay, do you have any questions for me, Mr. Bates? Okay, you're free to go back, sir.
Next is Mr. Beavers.
Mr. Beavers, you're charged with 1 count of driving a vehicle on a suspended license. The bond is automatically set at $1,500. Do you believe you can post that bond?
Already posted.
Okay. So once you go back from this proceeding, they're probably going to let you know that the bond has been posted and you're going to be free to go. The preliminary hearing date of June 15th is going to get waived automatically because you're bonding out. Do you plan on hiring your own lawyer representing yourself or?
Yes, I'll get my own lawyer.
Okay. Do you have any questions for me, Mr. Beavers?
Yeah, my bond's already been posted. I just received it on.
So because it takes a lot of movement, sometimes before you're able to have it posted, you're already placed in the queue or the line or the people for first appearance. So that happens from time to time. And sometimes I'll have people who they are on my docket, but they don't show up because they've posted bond. And so it just kind of the luck of the draw sometimes. Okay?
Use the phone.
You will be allowed to use the phone when you go back downstairs or you go back to where you are.
All right, thank
You're welcome.
you. Next is Mr. Bishop.
Mr. Bishop, you have 1 count of use or possession of drug-related objects and 2 felony drug charges. I'm showing that you're on probation out of Cobb County, so I can't set bond on those offenses.
Let him finish. Hey, be quiet. Let this one.
You will be able to speak. As you've heard, I always ask people if they have questions. So you're going to have a preliminary hearing date set for June 16th at 8:30 in the morning. You're going to have a bond hearing date set for June 18th at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer?
Please.
I'm sorry?
Yes, please.
Okay. All right, you do qualify. I'm going to appoint a lawyer to represent you. Now, what is it that you wanted to tell me?
I'm not on probation anywhere. My probation in Cobb County ended years ago.
Give me a second. I'm going back to your criminal history. Okay. So I see a number of probation violations. I see back in 2015, it says confinement, 60 days, credit with time served. What happened on that? It was May 12th of 2015.
I had a probation violation in Cobb, and I turned myself in to serve the time, and my probation was supposed to be over with after that.
Okay. Okay. All right. I'm going to set a $5,000 bond on each charge of the drug charge. So you're going to have a total bond set at $11,500. So you're going to have a preliminary hearing date still set for June 18th, and you don't have to worry about the bond hearing date. Any other questions?
No, sir.
All right, you're free to go back.
Next is Mr. Cox.
Good morning, Your Honor.
Good morning, Mr. Cox. You're charged with 1 count of family violence battery. I set the bond at $3,000. Do you believe you can post that bond?
Yes, sir. Good.
I've also placed a stay away provision on the bond to stay away from Isaiah Jones. So you understand that?
I understand.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Okay, I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Not at the moment, no, sir.
Okay, you're free to go back.
Next is Mr. Gatson. The last name ending in Cuozzo, Carson, OTB.
Thank you. Mr. Gaston, sir, you're charged with 1 count of robbery, 1 count of family violence battery. I'm denying bond on the robbery charge. I've set a $5,000 bond on the family violence battery. There's going to be a stay away provision on your bond to stay away from Rosanna Gardner. Do you understand that?
Sir.
You're going to have a preliminary hearing date set for June 16th at 8:30 in the morning. You're going to also have a bond hearing date set for June 18th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. That's not me. The birthday and the name and the social security number. that was given.
So when you say that's not me, can you kind of
Like,
help me understand?
like somebody else gave my name, that wasn't me. I was locked up in Henry County.
Okay.
I just
So
got,
I'm sorry.
just got released from Henry County. I wasn't out.
So that's something, Mr. Gaston, that I can't make a determination of right now because I don't have anybody I can ask questions about as it relates to that. If it sounds like you're telling me that you were wrongly named or charged.
Yeah, like that's not my name. Like it's not my birthday or my social.
So what is your name?
My name is Bradley Gaston, but it's not like my birthday or social. Somebody gave my name. That's what I'm saying.
I don't understand what you mean when you say somebody gave your name.
Somebody used my name. They used my name. I didn't, and the police let them use it. Like, that's not my social or my birthday.
Okay, so I've appointed a lawyer to represent you, and that's something that the lawyer will be able to gather that information and take it to the district attorney's office. What I'm saying is I don't have anything in order to verify what you're telling me. Okay? So that's why we go through this process of appointing lawyers as quickly as possible so that people like yourself can get to the lawyer, say, that wasn't me. I have an alibi, I have whatever. And the lawyer can take that to the district attorney's office and they can say, oh, we made a mistake. Okay? Any other questions? Okay, you're free to go back.
Next is Mr. Hood. Good morning, Your Honor.
Good morning. Excuse me. Good morning, Mr. Hood. You're charged with one count of cruelty to children in the second degree, and that's a felony, and one count of family violence battery as a second offense, and that's a felony. Bond is going to be denied on both of these offenses at this time. There's going to be a stay away provision on your bond to stay away from Megan Aline Valdez, and also to stay away from Francis Labrador. Do you understand that? You're going to have a preliminary hearing date set for June 16th at 8:30 in the morning, and you're going to have a bond hearing date set for June 18th at 8:30 in the morning.
I was trying to wonder why my bond was denied.
Hold on. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, what were you trying to tell me?
I was qualified for a bond application. I know it's not for you to rule over the case right now, but I work for quality manager for Coke, and I'm going to lose my job, my home, sitting for to June for a court date. I was wondering if you grant me bond so that I can get out, because it's just me and my girlfriend was arguing with allegations.
Okay, so the battery and the family violence second degree, that's the main thing that's stopping you, because it's a second or subsequent offense. And the allegation is here as it relates to the juvenile that you punched. Let's see. No, it's not that you punched her. It's that you allowed her to see you punching her mother in the neck in front of her. They also sought a kidnapping charge against you that the judge denied the kidnapping charge.
It never happened. What happened was in the front yard, the kids in the house.
Okay, so because of the family violence battery in the second or subsequent offense, that's the main thing that's holding you.
Yeah. But young, if I see it that long, I'm lose my good job with Coke, quality manager, but me and my girlfriend arguing, and that never happened. If I could just get bond to get out to get back to work you know, to keep my house and stuff. You know, I just don't want to see it in June and I lose everything I got over just an argument, you know.
I'm not unsympathetic to you, Mr. Hood. But you are living here. Where are you gonna go?
I'm gonna go to my mom's house at 851 Mill Street. We was living up together. And that's the thing about it. She told me that I had a warrant on me at work. So I took off of work yesterday and turned myself in, thinking that I would be able to get out to get back to work. She didn't want to contact me. I didn't even know it was a warrant on. I didn't even know she had called her. I turned myself in yesterday at 8 o'clock. And I told my job I'll be back by Monday or tomorrow. I just wanted to get out to keep my job. I want to get out and be rock bottom homeless with that in the car note over an argument with my girlfriend.
So I know you're saying that it's an argument, but what she's saying happened is that it was more than just an argument.
I'm being honest, I can't. Your Honor. It wasn't an argument. She had a water motion. I don't want the criminal to tell what happened in the case. It was in the front yard. When she made the report, she didn't even make it at the house. She told me she made it at a food restaurant. And she told me at my job yesterday, she said the police came and showed one. So I came back and turned myself in. I was never even on, none of that never happened. She said, we was outside of the house in the front yard, having a discussion. The lady name you called, Miss Betty, is the other woman name. I don't even know who that is. I know who Megan is. I don't know who the other lady is.
The Francis Labrador?
Yeah, I don't even know. I don't even know who that is.
That's the child of Miss Valdez.
Oh,
I'm sorry, sir.
that's her daughter. So my daughter was in the house. I don't know.
Okay, well, I'm not inclined to grant you bond, Mr. Hood. Let me see. I have appointed a lawyer to represent you. I would suggest that you tell this to your lawyer. Because if what you're telling me is true, somebody that you care about and you're living with is lying on you.
Yeah, it was a whole other person who was like a guy that's in the car who was outside. Argument happened outside. She had a male friend. Got into a dispute in front of the driveway.
Okay. Anything else, Mr. Hood? Okay, you're free. I'm sorry.
When is that going here again? When is my court date?
So it's set for June 18th. Now, unfortunately, I see too much of this, and I'm pretty certain that things are gonna die down, and somebody's gonna be calling the district attorney's office talking about they want to drop the charges. I can't like look into the future as it relates to that, but all I can tell you is that I see too much of this.
I understand you. I just don't want to lose my car and my job. I work in quality management court. When I get out, I'm not gonna have nothing. That's all. I just want to get out to keep my job and keep paying the car note. I don't want to get out the bottom and find myself back in the system. You just grant me fun to get out.
I understand that, Mr. Hood. The feelings that you're having right now are the feelings that you should have been having before you got into an argument with your girlfriend out in the front yard, as you have alleged, because it sounds like you weren't thinking about the things you had to lose at that point.
Your Honor, she actually, to the water to get me. My actually just swiped the water and get in the car. That's why she said, I got in the car. I left her. But if one more time thinking, I just want it done, so I'm gonna lose my job at court. That's probably not there in my car. But when I get out, I'm not gonna have nothing. So I just need to get out there and just keep my life, sustain my lifestyle.
So, Mr. Hood, when you were arrested in DeKalb County and it was accused, and it was dismissed on, what is that? On June 18th of 2012 for warrant of prosecution. And what that says to me is that person made the allegations against you, you were arrested. They thought that there was enough there to prosecute, and then the person just didn't show up. So I don't want you to get into it. I'm not trying to get you to get into it. I'm just trying to give you a window into what I have to look at, because I don't know you. I only have to look at the stuff that I have before me. And the allegations here and the stuff I have before me says to me that you may not understand even when you get angry. I had a woman the other day that every time she hit somebody, it was always because somebody did something to her. And she's swinging frying pans, she's doing everything, and she's like, I'm a victim, because in her mind, she was justified in doing what she was doing. So I need you to think about this for a little bit, and and they may grant you a consent bond, but right now you're not getting a bond.
Young, in that case, she was arrested too, but she busted out my window. That's why we did this. She was arrested.
You gotta pick. You gotta make better choices, Mr. Hood. All right, you're free to go back.
Mr. Hernandez was OTV, Your Honor. So next is Mr. Leighton.
Sir, you're charged with 1 count of loitering, prowling, 1 count of obstruction of an officer, and 1 count of possession of marijuana less than an ounce. You're gonna have a total bond set at $4,000. Do you believe you can post that bond?
No, Your Honor.
Okay. Your preliminary hearing date is going to be set for June 15th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
I'm just trying to do my time, you know.
Okay, so a lawyer is a person that could help you. And if you don't want the lawyer, you're just probably going to sit here a lot longer than you need to.
All right, yes, I do want the lawyer.
Okay. You qualify. I'm going to appoint a lawyer to represent you. These are low-level charges. You're probably going to be placed on the soonest, the fastest calendar they have for Mondays when they do these pleas. Do you have any questions for me?
No, Your Honor.
Okay, you're free to go back.
Next is Mr. Madden.
Good evening, Your Honor.
All right, Mr. Madden, you're charged with 1 count of simple battery. The bond is going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
You're going to have a stay away provision on this bond to stay away from Phoebus Gresham and Felicia Gresham. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for June 15th at 8:30 in the morning. That day will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
All right, you're free to go back.
Thank you.
Next is Mr. McDowell.
Mr. McDowell, you're charged with 1 count of criminal trespass. The bond is going to be set at $1,500. Do you believe you can post that bond? I'm sorry, sir. Would you say that one more time?
No, sir.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning. That date will get waived upon your bonding out, and you will get a new court date in the mail. Do you have any questions for me? Okay, you're free to go back, Mr. McDowell.
Next is Mr. Seymour.
Mr. Seymour, sir, you're charged with 1 count of criminal trespass. I set the bond at $2,000. Do you believe you can post that bond?
Yes, Your Honor.
There's also going to be a stay away provision on the bond to stay away from Ashley Greer. Do you understand that?
Understand.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I wanted to ask for a conditional discharge, but I'm not sure if this is the point at which I do that.
No, this isn't the point. Okay. Anything else, sir?
No.
Okay, you're free to go back.
Next is Mr. Smith.
Mr. Smith, you're charged with 1 count of driving on a suspended license and 1 count of driving a vehicle with an improper display of tag. Total bond is going to be set at $2,000. Do you believe you can post that?
Yes, sir.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes. I'm sorry.
Did you say yes?
Yes.
Okay. Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Next is Mr. Tiller.
Mr. Tiller, sir, you've been charged with 1 count of loitering or prowling. The bond is set at $1,000 for that. Do you believe you can post that bond? You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. Anyway.
Hold on 1 second. All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, I didn't hear the last thing you said.
Anyway, I'm on your big step.
No, sir. Anything else?
No.
Okay, you're free to go back, Mr. Tiller.
Next is Mr. Watkins.
Mr. Watkins, sir, you're charged with 1 count of family violence battery and 1 count of theft by taking. You're going to have a total bond set at $7,000. Do you believe you can post that bond?
Can I give it to $5,000 total, sir? If I'm begging because I have the money and I already did the calculation and I got somebody that'll come and get the money. But the money I have has got to be at least a total of $5,000. And through the bonding company, I'm trying to keep my job. I'm not gonna go back around the female. I got somebody I can stay with in Gwinnett County. I don't live with the female. And I'm just trying to keep my job. I actually turned myself in when I found out that I had the warrants on me. And it shot my blood pressure up. I went to the hospital. And I have like $600. The bonding company said if I can get it to 5,000 with the 600, then I'll be able to bond out tonight. But 7,000, I'm just pleading my case, sir. If you could just make the total bond at least 4,000 or 5,000, that'll really help me out tonight. I'm just trying to keep my job, so.
I understand that. I do. The thing I don't understand is how. So the allegation is you kicked in her door and grabbed her by the hair. Hold on. Allegation is you kicked in the door of her apartment, grabbed her and drug her around by her hair, and then you held her by the hair in her head in an event to prevent her from fleeing. and that you were punching and kicking her in the arms and legs while she was curled up in the rear corner of her apartment. Now, if that was your daughter, Mr. Watkins, and I was here asking you for leniency because I did that stuff to your daughter, what would you say to me?
I was probably say, because I have two little girls. But at the same time, like, I know I would have to go through the process and stuff like that. It's not here or there to say that I'm guilty or not.
Right.
Because when I found out I called the officer, I turned myself in. I went back.
No, I understand that. And you're getting a bond.
Yes, sir. I'm just saying, like, the money I have on my card, for me to bond out, the bonding company, wherever my folks already talked to them, I have to have at least the total bond had to be 5,000. Sir, I would not come back to Clayton County if you grant me this bond until it's time for you to go.
Hold on one second, Mr. Searles.
And I haven't gotten in trouble in 8 years.
Hold on, that's what I'm looking up. That's the thing. It kind of falls on deaf ears when you tell me about the stuff that you have to lose, when you had those things to lose in the beginning. It doesn't make me think that you really, really care about the stuff that you have to lose. You know what I mean?
Yes, sir. I heard you explaining that to the other guy.
Well, I mean, it's you know, that's generally why people don't do things, is because of the stuff they have to lose. Mr. Watkins.
Yes, sir.
You have a battery from 2004.
That was in 2004.
Yeah, well, you spent 6 months in jail. Right?
Yes, sir.
Then you got charged with aggravated assault in 2005.
I wound up beating that case. They dismissed that case.
I understand.
I understand what you're saying, sir. Like I said, I haven't got,
So, Mr. Watkins, I really, I understand that you really want to drop this down and make it easier to get out.
But I just thank you for allowing me to have a bond anyway, because I was seeing that you didn't get some of the guys a bond. So I just thank you for that, sir. I'm grateful.
Mr. Watkins, it looks like you may have some issues with either impulse control or anger management, because everything that I see that you're getting arrested on is like stuff that you disorderly conduct, batteries, all of that kind of stuff, that you're just not controlling yourself.
I haven't had nothing to drink in 2 years, and I had something to drink 2 nights ago.
All right. I'm going to leave it the way it is, Mr. Watkins. Okay?
Thank you, sir.
All right. You're free to go back.
Okay. Next is Mr. Wilson.
Okay. Mr. Wilson.
Yes, Your Honor.
So normally I would not grant bond on this kind of charge, but you don't have a significant prior criminal history.
Yes.
So I'm going to set a $15,000 bond on this charge, with a condition that you stay away from Cedric Watson. The way that this is written tells me that there's more to the story, but we're not here to talk about the facts of your case.
I appreciate that, Your Honor.
would you, you're gonna have a preliminary hearing that's gonna be set for June 16th. That date is gonna get waived upon your bonding out, and you'll get a new court date in the mail. Do you understand the stay away provision to stay away from Cedric Watson?
Cedric Watson, I don't think belongs, I don't think he works for that company anymore that we had the altercation with.
Okay,
I think he-
okay. Do you want me to see if you qualify for the appointment of a lawyer?
No, Your Honor.
Okay, you're gonna hire your own lawyer? Okay, any questions for me, Mr. Wilson?
No, I appreciate that you're taking a look at both sides of it, and it's not been resolved. I've never been a felony against me ever, nothing like that.
Right. Okay, you're free to go back, sir.
Next is Mr. Walker.
Mr. Walker, you're charged with 1 count of loitering or prowling. The bond is automatically set at $1,000. Do you believe you can post that bond? You're gonna have a preliminary hearing date set for June 15th, but that date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
That would definitely help me out.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back.
Your Honor, Mr. Ward is OTB. Next,
Okay.
Mr. Williams.
Mr. Williams, you're charged with 1 count of loitering or prowling. Bond is automatically set at $1,000. Do you believe you can post that bond?
Excuse me. Only thing I'm doing is just scratching out some tickets, and I have high blood
Hold
pressure.
on,
Hold on. I'll let you speak in a second. You're gonna have a preliminary hearing date set for June 15th at 8:30 in the morning. That date will get waived upon your bonding out and you will get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Now, what is it that you want to tell me, Mr. Williams?
I was just scratching out tickets, and they said I was sitting there too long for a lot of them. And I would stay next door to the store. I've been there 25 years. And I have high blood pressure, and I take a lot of medication. All my medication is at home. June 16th, I had to sit that long to go to the court.
June 15th is the preliminary hearing date. This loitering or prowling is a relatively minor offense. And just so you know, the allegation is that you're sitting on the curb of the property drinking a beer. And they say that they watched you for about 15 minutes, and that you were stating that you were there waiting on someone for an hour or so. So just so you understand, I see a number of these, and generally it comes from places that they've received phone calls of people just hanging around, milling about. So if you are in a place like that, you may want to just not be there, because there is a chance that you'll just come and they'll just arrest everybody just to clear the property. Okay?
I have to wait till, let's say, June 15th.
I've appointed you a lawyer. The lawyer probably will get you out before then. But this is something that's set by schedule. So
I just, my blood pressure medicine, and I just see too. That's what I'm trying to put the medicine at home.
So if you're still here, make a call that you need to talk to somebody. I mean, a call or slip or however they do it in the jail, to notify them that you need to speak to somebody about your blood pressure medication. Do you have someone that can bring you blood pressure medication?
I believe my sister.
Okay. So those are things that I think you should take those steps. But I'm telling you, from what I've just seen today, it looks like this 80 8075 Highway 85. I think you're maybe the fourth person or fifth person I've seen today arrested at that location. So that's probably not a good place to hang out. Also, 330 Arrowhead Boulevard, I've had probably 20 people arrested there. So
You see, if I get appointed a lawyer, it might be earlier than June 15th.
yes, sir. Or you can pay about $150 to a bonding company and get out. Okay. All right. You're free to go back.
Next is Mr. Wright.
Mr. Wright, how are you doing, sir?
All right, sir.
You've been charged with 1 count of obstructing an officer and 1 count of improper lane change. I've set a total bond at $1,500. I'm sorry. I'll set a total bond of $1,500. Do you believe you can post that bond?
Sir.
You're going to have a preliminary hearing date set for June 15th at 8:30 in the morning, but that date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir.
I'm sorry?
Yes, sir.
Okay. Are you currently working, Mr. Wright?
Yes, sir.
About how much do you make per hour or per month?
24. Well, I got unemployment, so same thing.
Okay. Okay. All right. I'm going to find that you qualify and I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay. You're free to go back.
Thank you, sir. Hey, stand over there by them big men. Okay, y'all, that completes the right there.
Okay. Hold on. I got a question for you, Deputy Cox. Hold on. Let me release this.